Friday. Federal judge froze Trump Organization bank accounts. All of them. $427 million. 17 accounts. Immediate effect. According to emergency order filed at 6:34 p.m., extraordinary risk of asset dissipation. I've got the 41 pages. Page 28 shows wire transfer attempts to offshore accounts Thursday night. Here's what they're not covering. Page 33, $84 million moved to shell companies in the Cayman Islands on Wednesday. That's the court filing, not speculation. But that's not the worst part. The forensic accounting report attached shows a pattern. Every time a major ruling goes against Trump, large transfers happen within 48 hours. Monday at 10 a.m., contempt hearing, clocks running. Let me show you what Judge Engoron found. Quick context. Donald Trump, former president, defendant in New York, civil fraud case. The issue, $454 million judgment from February 2024 remains unpaid while appeals continue. Timeline fast. February 2024, Judge Engoron issues $454 million fraud judgment. March 2025, appeals court reduces to $427 million, upholds liability. August 15th, 2026, emergency freeze order after evidence of asset movement. That's the setup. Now what's in Judge Engoron's order that everybody missed? The emergency order. Page 14. Forensic accountant identified $127 million in transfers to 23 entities created in the last 90 days. Direct quote. All entities share common beneficial ownership structure obscuring Trump Organization control. That's asset hiding. Page 19. Thursday night at 11:47 p.m., wire transfer request for $31 million to Cayman account. Flagged by compliance department, ultimately blocked by receiving bank. Connects to the pattern. He's moving money the night before the court filing. That's not coincidence. Gets worse. Page 22. 3 properties transferred to Trump Jr. and Eric Trump for $10 and other consideration. Market value, $67 million combined. 3 findings. Same pattern. Shell companies created recently, offshore wire attempts at night. Property transfers for nominal amounts. All documented. Pages 14 to 28. But wait. Exhibit C shows communications between Trump attorneys and foreign wealth management firms. That's not estate planning. That's judgment avoidance. Timeline proves intent. August 7th. Appeals court signals ruling coming soon. August 10th. First shell company created August 12th. $84 million moved offshore August 14th. Wire attempt at 11:47 p.m. August 15th. Emergency freeze order. 8 days between warning and freeze. Planned. Page 33 breakdown shows the $84 million Cayman transfer. $31M to DJT Holdings International Limited, created August 10th. $28M to American Property Ventures SA, created August 11th. $25M to Empire Consulting Group LLC, created August 12th. All 3 companies. 0 operating history. Identical registered agent. Judge Engoron's conclusion on page 38. Defendant has engaged in systematic effort to place assets beyond reach of judgment creditors through fraudulent transfers and offshore structures. Not concerns about or potential for. Systematic effort. That's fraud on top of fraud. Subscribe. More documents dropping on this. Friday, 6:34 p.m. Here's what happened. Judge Engoron issued emergency temporary restraining order. No advance notice to Trump's team. Defendant will immediately cease all transfers, encumbrances, or disposition of assets. Trump's attorneys, blindsided. First learned via court filing alert. Immediate consequences. All Trump Organization bank accounts frozen by 7:15 p.m. 3, pending real estate sales halted within 90 minutes. Offshore wire transfers reversed by 9:42 p.m. 3 hours and 8 minutes. That's how fast this moved. While everyone focused on the account freeze, Engoron simultaneously appointed a special master with authority to trace assets. Retired FBI forensic accountant Barbara Navarro. Unlimited subpoena power. New York Attorney General's Office response. Filed supplemental brief at 8:23 p.m. requesting contempt sanctions. That's documented in AG docket entry 847. This isn't just asset preservation anymore. Criminal contempt territory. Trump's lead attorney Christopher Kesey released statement at 9:47 p.m. This is election interference disguised as legal process. Not we dispute the findings. Not will comply pending review. Defiance. By 11 p.m., the special master had issued 14 subpoenas to financial institutions. Banks in New York, Florida, and the Cayman Islands. She's tracing everything. Trump posted to Truth Social at 11:34 p.m. Corrupt Judge Engoron stole my bank accounts. This is what happens in communist countries. All caps. No mention of compliance. This changed everything. Like, if you're seeing what I'm seeing here, here's what nobody caught. Appendix F shows this isn't the first time. Forensic analysis found similar transfer patterns before 3 previous adverse rulings. January 2024, week before fraud verdict. $43M moved to foreign accounts June 2024. Week before bond reduction denied. $29M transferred November 2025. Week before appeal argument. $38M moved offshore. This wasn't in mainstream coverage. This is a system, the connection. Every time a major court date approaches with potential bad news, large offshore transfers happen. That's not financial management, that's a playbook. Numbers tell the story. $127 million in recent transfers. $110 million in previous pattern transfers. $237 million total attempted asset flight. All within 24 to 48 hours of court developments. Why this matters? Each instance is potentially a separate fraudulent transfer count. Pattern evidence proves intent can't claim business as usual. Former U.S. Attorney Preet Bharara confirmed pattern evidence transforms the case. Quote, one transfer is a transaction. Multiple transfers before court dates is consciousness of guilt. That's independent verification from former federal prosecutor. This changes the criminal exposure Trump faces. Judge Engoron noted the pattern on page 39. The temporal correlation between adverse legal developments and asset movements demonstrates willful judgment evasion, not legitimate business activity. He's not just freezing accounts. He's documenting a fraud pattern spanning 2 years. How we got here. February 2024, Judge Engoron issues $454M fraud judgment after finding Trump inflated asset values for loans and insurance. March 2025, Appeals Court reduces judgment to $427M, but upholds all liability findings. Trump must post bond or pay. May 2025, Trump fails to post bond. Claims he can't find surety company to back him. Quote from back then, no bonding company will accept real estate as collateral in this amount. What happened? Requested multiple extensions. Filed emergency appeals each time. Delay granted. No payment made each time. Avoided immediate payment. Until August 15th, 2026. AG's office finally filed forensic accountant report showing asset movement pattern. What broke the pattern? Offshore wire attempt at 11:47 p.m. Thursday was flagged by International Banking Compliance Systems created paper trail showing active concealment. Stay with me. What experts are saying changes this. What experts are saying? Former federal prosecutor Glenn Kirshner, 30 years DOJ. Fraudulent transfer plus contempt equals potential criminal charges. Translation: moving assets to avoid judgment isn't just civil, it's criminal fraud. Forensic accounting expert Jennifer Taub. Shell company creation followed by immediate transfers is classic concealment. Keyword: classic. Means textbook fraud indicator used in prosecutions. Even Trump ally and attorney Alan Dershowitz. If the transfer timeline is accurate, that's problematic. When Trump's own former defenders use problematic, serious legal exposure. Consensus. Pattern evidence eliminates legitimate business defense. Offshore timing shows intent to evade. This exceeds civil contempt potential criminal territory. That's professional analysis, not spin. Former assistant U.S. attorney. I prosecuted asset concealment for 12 years. Creating shells, moving money offshore, timing it around court dates. That's my opening statement written. Banking compliance expert. The 11:47 p.m. wire attempt is devastating. Legitimate transactions don't happen at midnight with offshore destinations. Former New York Attorney General Eric Schneiderman. Pattern evidence across multiple court dates shows this isn't reactive. It's systematic evasion. Bankruptcy fraud specialist. Each fraudulent transfer is a separate count. That pattern could be 15 to 20 charges. Legal ethics professor. Attacks on the judge while violating orders compounds the problem, shows contempt for judicial authority. Range of specialties, same conclusion. Even conservative legal analyst Jonathan Turley, the remedy for disagreeing with a judgment is appeal, not asset flight. Former Trump Organization executive Barbara Rez. This is how he's always operated. Delay, deny, move money. White-collar crime prosecutor. Special master appointment is critical. She has FBI background in international asset tracing. All point to significant criminal exposure beyond the civil judgment. Fair counterpoint. Trump's legal team says these are standard business transactions during appeal process. Their case, moving assets between corporate entities is routine business practice for organizations this size. No judgment is final during appeal. Trump has legal right to manage businesses normally. Attorney Christopher Keese. Every transfer was documented and involved legitimate corporate restructuring. That's legitimate. What they have? Appeals process, still active judgment, not final. Some transfers were to family members managing specific properties. Even legal analyst notes. Proving fraudulent intent requires showing transfers were solely to avoid judgment. But page 33 shows all three shell companies were created after the appeals court ruling signaled affirmance coming. That's not routine restructuring. That's preparation for judgment. Both sides have arguments. Documents say entities created days before transfers with no business purpose except receiving money timed to court developments. Like if this breakdown is useful, why this matters to you. If you've ever dealt with the legal system, this establishes whether wealthy defendants can move assets to avoid judgments. Numbers. $427 million judgment. $237 million in attempted transfers. Your justice system. If this works, Judgments become meaningless for those with offshore access. The precedent. Next time wealthy defendant loses case, can they just move money overseas? Example. You win lawsuit against someone with money. Court awards you $500,000. Before you can collect, they transfer assets to shell companies in the Cayman Islands. Before this case, complicated, lengthy process to stop them. After this case, emergency freeze orders with forensic special masters become standard practice. Who gets hit? Every judgment creditor trying to collect from sophisticated defendants. Asset protection attorneys already advising clients on new compliance requirements. Bottom line, if you believe court judgments should be enforceable regardless of wealth, this case determines whether asset flight works. What people are doing. Forensic accountants seeing increased demand from judgment creditors. Courts implementing faster freeze procedures when asset movement detected. Knowledge helps. How Trump responded made it worse. Posted 47 times on Truth Social between Friday night and Saturday morning. Sample. Engoron is a corrupt hack who should be in prison, not me. Reaction. Legal experts noted posts could be used as contempt evidence. Special master cited post in supplemental filing requesting enhanced monitoring. New York AG Letitia James responded, Mr. Trump's social media threats will not deter enforcement of lawful court orders. Then, Saturday morning, Trump's team filed emergency appeal to Second Circuit, requested immediate stay of freeze order, not de-escalating. Each attack on Judge Engoron strengthens contempt case show's pattern of defying judicial authority. Trump attorney Alina Habba appeared on Newsmax Saturday. This is election interference. President Trump can't even access his own money. Didn't address the offshore transfers. Didn't address the shell companies. Didn't address the timing pattern. Political defense, not legal defense. By Saturday afternoon, Trump Jr. posted, "They're trying to destroy my father because they can't beat him at the ballot box." 3 Trump family members now publicly attacking the judge. Special Master Barbara Navarro's office issued statement. Personal attacks on the court do not constitute legal argument and will not impede forensic investigation. Professional, focused, not engaging the circus. What's coming? Monday, August 17th, 10 a.m., contempt hearing in New York Supreme Court. 3 possible outcomes. Trump appears and complies, provides full asset disclosure. Freeze remains, Trump appears and defies contempt sanctions. Possible arrest. Trump doesn't appear, bench warrant issued. Former federal judge Shira Scheindlin says outcome 1 most likely because Trump's attorneys will force compliance to avoid arrest. Also scheduled. Tuesday, August 18th, Second Circuit hears emergency stay appeal. Friday, August 21st, Special Master preliminary report due on traced assets still unknown. Whether criminal charges will be filed for fraudulent transfers. What other assets the Special Master investigation will uncover. The Monday hearing determines whether Trump provides full financial disclosure under oath 48 hours from now. Special Master has authority to subpoena any financial institution globally, compel testimony from Trump Organization employees, trace assets through multiple corporate layers, refer findings to prosecutors. Her preliminary report Friday could reveal total assets actually available versus claimed, additional offshore accounts, other family member involvement, full scope of shell company network. That report is public filing. If Second Circuit denies stay on Tuesday, freeze remains in effect through full appeal process. Could be 12 to 18 months, $427M plus interest accruing. Interest calculation. $427M at New York statutory rate of 9% equals $38.4 million per year. Every year this continues, judgment grows by $38.4M. The contempt hearing Monday determines whether Trump faces additional sanctions beyond the freeze. Judge Engoron has authority to impose daily fines until compliance, $10,000 plus per day. Typical incarceration for civil contempt. Criminal contempt referral to prosecutors. Appointment of receiver to take control of Trump Organization assets Monday morning. 72 hours since the freeze. Subscribe. I'll break down what happens at Monday's contempt hearing. That's where we are. Donald Trump, 17 bank accounts frozen. $427 million judgment unpaid. Facing contempt hearing Monday. Surface read, judge enforcing civil judgment. But the pattern evidence shows systematic asset concealment spanning 2 years, timed to court developments, using offshore structures that's criminal fraud territory. Monday's hearing determines whether Trump provides full asset disclosure or faces escalating sanctions. Stories moving. Subscribe for the breakdown when Monday's contempt hearing concludes. I read the documents so you don't have to. 41-page emergency order. Every exhibit, every wire transfer detail, every shell company formation document. Complete forensic accounting analysis showing the 2-year pattern. Page 28, the Thursday night wire attempt. Page 33, the Cayman shell companies. Page 39, Judge Engoron's pattern analysis. Appendix F, the complete 2-year transfer timeline. Monday, 10 a.m. One way or another, we'll know if Trump complies or defies. More coming.